Hello, welcome everyone, and thank you so much for joining us. From the panelists, can you give me a thumbs up if you can hear me okay? Great, wonderful. My name is Doug Kaiser. I'm professor of law at Yale University, where I direct the program in law, ethics, and animals. It is currently 4 a.m. in the United States, where I am zooming in from. And there's only one reason that I would be up this unconscionably early. And that is to say before an international audience that Jolene Lin is the greatest collaborator one could possibly ask for. We're celebrating today a launch of a book volume that we have co-edited and that will soon be released by Cambridge University Press. At every stage of this project, from conceiving and executing the conference that originally solicited the papers that will be published, to the very final read of the proofs, at every single stage, Jolene has been wise and warm and wondrously efficient. So I just want to say for the record, and we are being recorded, everyone should know, I just want to say for the record that she is a terrific friend and colleague. And so now, without further ado, I'm going to turn things over to Jolene to tell you more about the book.
Thank you, Doug. So actually, I wanted to begin by welcoming everyone and also saying the same about Doug. So thank you very much, everyone, for making the time to attend this virtual book launch. It is the launch of an edited collection, bringing together 14 chapters that examine climate change litigation in the Asia Pacific. And this is a particularly meaningful project for me because this is the first research project that I convened upon joining the National University of Singapore. And when my son was 2 months old, so I feel particularly proud because my brain felt a bit mushy during that period of time. I'm really grateful to Doug for having agreed to work with me on the project, and it's been a fabulous experience. There are a number of people I want to thank for making the book possible, and I'm going to do so before we turn to the speakers who have so generously offered their time to provide us insights into the trends and events that have happened in the space of climate litigation in the Asia Pacific since we first convened the research workshop in 2018. So first, I want to thank the then manager of APCEL, the Asia Pacific Center of Environmental Law, Melinda Tan, for just meticulously planning and executing the workshop with her usual cheer and efficiency. I've always been very grateful to Melinda for helping me with the first 2 years of my time as director of the Asia Pacific Center of Environmental Law. I've got a couple of my research assistants tune in, and that's been my ex-research assistants, Kara Yuen, Vanessa Yun, Eden Teo, Daniel Ling, and Sean Rafiti Tenadi, who have been such amazing support during the editorial process for this book. And of course, I also would like to take the opportunity to thank one of the speakers, Professor Jacqueline Peel. Professor Jacqueline Peel and I collaborated on a chapter for one of the chapters in this book, looking at the opportunities and barriers for climate litigation in selected Southeast Asian jurisdictions. And that has just led to a much bigger research project examining the trends of climate litigation in the global South. So I don't know how we came from 3 Southeast Asian jurisdictions to looking at climate change litigation in Latin America, Africa, and Asia. And the both of us would be co-authoring a book. And I'm really excited about that. And so that would be something, I guess, another book launch to look forward to, and hopefully in person. Without further ado, I just want to thank the speakers, and I'm gonna get, Doug has kindly offered to introduce the speakers who would each present for about 15 minutes about some of the latest developments and interesting cases in their jurisdiction. So over to you, Doug.
Thank you. Yeah, so for the book launch, we rather than sort of like focus on the chapters and content of the book itself, we really wanted to use it as an occasion to invite experts from around the region to give us some insights and updates on what's happening with respect to climate change litigation, um, sort of subsequent to the 2 years ago when we convened our original conference. And we've been very, very fortunate that four leading experts and advocates have agreed to join us for this webinar. And so that we can maximize the time that we can hear and learn from them, as well as engage with them through the question period afterwards, I'm just going to introduce them by their title and affiliation, rather than give you the lengthy and extremely impressive biographies that you can find on the APCEL website. And I'll introduce them in the order that we will be hearing from them. So first, we will hear from Jacqueline Peel, professor at Melbourne Law School. Then we will hear from Zhao Ye, associate research fellow at Sichuan University. We will then hear from Sejong Yon, director of the Solutions for Our Climate organization. And finally, Arpitha Kodaveri, who's a doctoral researcher at the European University Institute. So, Jacqueline, please take it away. Thank you.
Thanks very much, Doug, for that introduction, and Jolene also for the lovely introduction and plug for our new forthcoming book, which we have yet to write, but that will motivate me to get onto it. So I'm hoping that you can see my slides. Just nod at me, Jolene, if they're coming up. Yep. Okay, so Doug and Jolene, as they said, asked us to focus a little bit in these presentations on some emerging trends and new developments in the field of climate litigation. And I'm focusing particularly on developments in Australia. And one of the reasons why Australia is included in the book and in this series of presentations is because of all the Asia Pacific jurisdictions, it is the one with the most climate litigation. And indeed has the second largest number of cases, only exceeded by the United States. So it's an important jurisdiction for understanding the role of climate litigation in the region, and also forecasting, I think, some of the future trends. So unlike a lot of the jurisdictions that you're going to hear about from other speakers, Australia is not an emerging climate litigation country, but rather one with an established climate litigation jurisprudence. So we have climate cases that stretch back to the 1990s, around the same time as you're beginning to see the emergence of climate litigation in the United States as well. Australia's climate cases number around 100 now. Many are cases that relate to issues of mitigation, focused largely on opposing Australia's love affair with coal-fired power stations and coal mines. But Australia has also had a very substantial jurisprudence focused on adaptation, with cases looking at developments that might be impacted by sea level rise, coastal climate change and increased fire and flood risks. Australia is a continent that is particularly beset by climate change impacts, which is one of the reasons why we've also seen such a large adaptation case law. One of the things that we probably haven't seen in Australia compared to some other jurisdictions like the United States is a series of very high profile cases. We haven't had what you might call a Massachusetts v EPA moment or a Uganda case in Australia. And part of the reason for this is that most of the cases are not brought before federal courts. We haven't had a climate case that has gone in Australia to our highest court, the High Court of Australia. Instead, most of the cases have been decided by state level specialist environmental courts. That has certain advantages in that these courts tend to be easier to access from an environmental access to justice point of view, with open standing rules and favourable cost rules. But it does tend to mean that these cases are not as high profile as some that have emerged in other countries. In looking at the jurisprudence in Australia and in the US, myself and a colleague I write with a lot, who also works with Jacqueline, Hari Osofsky, have talked about in Australia the concept of having first generation cases and next generation cases. I should hasten to say that the distinction between first and next generation cases is not intended to denigrate in any way the first generation of cases by suggesting that they are somehow lesser. Or that they have stopped and been replaced by a next generation. But in looking at these trends, we thought it was useful to classify the cases in these two different categories. So what we have seen in Australia in terms of first generation cases were ones that were largely focused on environmental impact assessment. So cases were largely challenging projects, trying to have included in the decision-making process issues of climate change, whether adaptation related or mitigation focused. These cases, by and large, used administrative law mechanisms under environmental or planning law, usually focused against governments and decision makers. And very characteristic of this series of cases, which continues today in Australia, largely focused on adaptation issues and also on big projects that could contribute to emissions like coal mines and coal-fired power, is that they have brought about incremental change rather than very high profile changes in the law. And by incremental change, I don't mean insignificant change. I just mean that the cases have gradually built a narrative around the importance of including climate change in environmental impact assessment. An example of a first generation case that actually has had a much higher profile in the sense of achieving a level of global recognition that perhaps some of the other Australian cases have not, is the recent case decided by His Honour Chief Judge Preston of the New South Wales Land and Environment Court, often called the Rocky Hill Coal Mine case, or its formal name is Gloucester Resources Limited v Minister for Planning, which was decided at the beginning of last year. And this case was the first decision, or one of the very first decisions, where an Australian court actually refused a new coal mine proposal. We've had lots of challenges to coal mines, but very few refused. And what was significant about this decision, which like the other first generation cases involved administrative law mechanisms and challenges to an environmental impact assessment, was the judge's reference to the issues of global climate change, greenhouse gas emissions and Paris Agreement targets as part of the justification for refusing the mine. Chief Justice Preston talked about a new open cut coal mine being in the wrong place at the wrong time. And by the wrong time, he was referring to the fact that a new project that would accelerate increases in emissions from coal that was being mined and then burned overseas was not the right kind of project in the current climate constrained world. What we've generally labelled next generation cases in the Australian context have a very different focus from some of these first generation cases. And the main distinction that we draw is that in these cases, there tends to be a much greater focus on government and corporate accountability directly for the harms that those actors bring about in causing impacts that give rise to climate change. What we're seeing in these next generation cases is a move away from administrative law mechanisms and a project-based focus to different kinds of legal avenues, for example, under tort law, corporate law or consumer law. Generally with the idea that the case itself has a more systemic impact. So it's a surgical intervention, if you like, on one particular issue, which aims to achieve a more strategic impact throughout the system. These cases in Australia are not many in number, but they have achieved quite a high level of media attention. And it's important to emphasise that they exist alongside ongoing first generation litigation that is more project focused. Some of the cases in this next generation category that have been particularly interesting and are very recent, so reflective of some of the trends that we're beginning to see, are those that are focusing on issues of financial risks posed by climate change. And Australia has emerged somewhat as a leader in bringing these kinds of cases, perhaps reflecting the fact that climate risk associated with businesses conducting a lot of their business based on fossil fuel business as usual is a particularly fruitful environment for these kinds of challenges. So these cases in general are challenging inadequate disclosure or management by corporate and other financial sector actors of the risks that might be posed by climate change to their businesses. And they take as their basis the idea that climate change is not just an environmental matter, but poses for many businesses financial risks for their bottom line, and that those risks under standard corporate law requirements need to be appropriately disclosed and managed. So the pathways we're seeing emerging here are in corporate and securities laws, as well as some analogous laws. And it's somewhat ironic for an environmental lawyer like myself to find myself in many presentations now talking more about corporate law avenues than about environmental law avenues, but have to go where the cases lead us. So I thought it might be useful in the last part of my presentation just to take you through some of these cases, which have been really very interesting and I think point to new directions for litigation, not just in Australia but elsewhere, mainly because the kinds of legal avenues that are being used in corporate and securities laws are very common throughout the region and indeed throughout the globe. So the first of these cases was brought against the Commonwealth Bank of Australia, which is one of Australia's 4 major banks. And it was a lawsuit brought by shareholders, or a particular shareholder, Guy Abrahams, who was arguing that the bank in its annual reporting, its filings that it needs to put in about the business on an annual basis, did not appropriately disclose climate risk to the bank from the kinds of things it was investing in, including at that time the very large Adani mine project proposed in Queensland. That case didn't actually go to court. It was settled, well, it didn't go to trial, I should say. It was settled after the bank agreed that, in fact, what it would do would be to increase its level of reporting on climate risk in its subsequent annual reports. And in fact, if you track through those annual reports, you can see a marked change in the amount of detail that the bank is now offering in relation to how climate change affects its asset portfolio. And very soon after the case settled, the bank also committed not to provide financing to this large new coal project in Queensland being developed by the Adani company. So that triggered off another series of cases, all of which are ongoing litigation. So we've had some preliminary decisions in some of these cases, or in other cases they've just been filed. They are attracting quite a lot of attention in Australia and outside Australia. One is a case being brought by Mr. McVeigh, who is in his 20s, against the REST superannuation fund. In Australia, superannuation funds is the term used to describe pension funds. So these are very large institutional investors who manage a lot of money, retirement savings for people. And in Australia, superannuation funds, your employer has to contribute to these on a compulsory basis. So the superannuation funds manage a lot of money. and they manage a lot of money over large and long time frames. So Mr. McVeigh, is a man in his 20s concerned about climate change, wanted to know more about how his superannuation fund was investing and how it was accounting for climate change risks in those investments. And that initial request for disclosure by Mr. McVeigh has led to subsequent litigation where he's now suing the trustee directors of the superannuation fund on the basis that they haven't fulfilled duties to adequately manage climate risk to the portfolio of investments that they have. Another case that's just recently been launched in July this year by the same law firm that is behind the McVeigh case involves sovereign bonds. And it's a case being brought by Cada O'Donnell, another individual, this time a law student in Melbourne, who's bringing a case against the Commonwealth Government, so the Australian Government, and also officials of the Australian Government, arguing that in that case, information statements that have been issued to investors in Australian government bonds don't appropriately disclose or adequately disclose risks associated with climate change that might impact on the value of those bonds over time. So the common theme of these new cases is a focus on different legal avenues beyond the administrative law mechanisms that characterise the first generation, a search for systemic impact through litigation, and also a focus on climate change as generating financial risk. I can see that Jolene's waving at me, which means that my time is nearly up. So I'm going to finish with just telling you about some of the cases that are on the horizon, literally just filed. One is a new case of Sharma v Minister for the Environment. This is quite an unusual case. It's not dissimilar to the famous Juliana case in the United States in that it's being brought by a group of Australian youth who are concerned about the effects of climate change on our environment and also particularly on the Great Barrier Reef. And in the Sharma case, the applicants there are suing the Minister for Environment in relation to a proposal for extension of a coal mine, arguing in fact that the Minister has a common law duty of care to safeguard the interests of young people from climate change impacts, and they're seeking an injunction to prevent the Minister issuing approval for that mine. The other development that's going full steam ahead at the moment is a lot of activity in the space of shareholder activism, with the possibility that this leads to litigation because the Australian government is seeing its way out of COVID through what it's calling a gas-led recovery, which seems to involve opening up major new gas fields for fracking in the northern part of the country that would generate and potentially lock in huge amounts of gas that could undermine a clean energy transition in the country. So this is, I think, where we're going to see a lot more of the emerging litigation in Australia in the next year or so. So that's all I have to say, and I hope that gives you a very short but hopefully interesting introduction to Australia's very rich past of climate litigation cases and also where it might be heading in the future. Thank you.
Thank you, Jackie, for a wonderful overview. A lot of food for thought in there. I was especially glad that you mentioned the McVeigh case, which I think is utterly fascinating. It sort of manages to take that intergenerational conflict narrative that we see in the youth versus government cases, but bring it in a private sector context. And I think that's absolutely fascinating. Just a reminder to everyone who's listening in, please feel free to use the Q&A function here on the webinar. So drop your questions in the Q&A box as we go along. And next, we are very, very fortunate to have a view from China. Zhao Yu, please take it away. Thank you.
Hi. Okay, thank you. Can you hear me? Can you guys hear me? Right? Okay. Okay, I'm very happy to meet all my friends here again online this time. Hello, Jacqueline, Doug, and Jackie, and Peter. Nice to see you again. And I'm we are really very much reassuring and inspiring to see you guys are doing well. And now, because the time is very much limited, I'll start my presentation. Okay, can you see the screen? My slides, okay. Okay, so this time the topic that I would like to share about is the climate change litigation and its potential pathways in China. And I would like to share my learnings about the following 4 questions. First, is there any CCL in China? And second, how does Chinese CCL differ from the standard account of climate change litigation? And third, what would be the most likely channel for possible climate change litigation in China? And the 4th aspect is some emerging trends of climate change litigation in China. And okay, for the first question, is there any CCL in China? When I first got the concept of the CCL, I was very much confused. I knew very few cases which might be related to the climate change litigation. So I went online, and what I found is are two documents issued by the Supreme People's Court of China. Both of these documents have mentioned a concept of the litigation as response to climate change, including 4 categories: the carbon emission, energy conservation, green finance, and biodiversity conservation. So I went to the court and asked the judges, what are these litigation as response to climate change are about? None of them could give me a very precise answer. So what I did, the team went to the China's judgments online, and we have extracted 177 cases. And based on this empirical study, we have some understanding of what's this litigation as response to climate change are about. We found there are 4 trends. First, these cases are mainly contractual-based contractual disputes, and they involves enterprises related to energy conservation and biotechnology. They are the plaintiffs and the defendants. And what's the most interesting part about this litigation is that all this litigation, a large part of this litigations demonstrate an obvious judicial tendency of the courts in favor of low carbon policy. Here, the win and neutral and lose, it doesn't demonstrate the subjective attitude of the judge, but we are trying to describe the effect of the case outcomes towards the climate change related issues. And the outcome is very impressive, as the rate of win cases among the 177 cases is rate to an average winning rate of 49.7% compared to the lose rate, which is only 70%. So it demonstrates that the court is in support of the governmental low carbon policy. And we also discovered that in these judgments, sometimes the courts will make direct reference to governmental policies. It's very unusual because the Chinese judges are considered should apply the law instead of governmental policies. But in these judgments, in this specific field, the judges do mention the governmental policy. And for example, in one cases concerning the installation of the solar power heating system, the judge expressly mentioned that as the defendant is in line with the energy saving and low carbon policy requirements of the government, then it should thus be supported and encouraged. And in other cases, there are similar expressions. So what we have seen from these cases is that there's a big gap between Chinese litigation as response to climate change and the standard account of climate change litigation. The Chinese climate change litigation are more likely to be in China, many involves actions related to contract disputes brought by or involving energy or biotechnology enterprises. But it's not the intention of the plaintiff to fight the climate change. It's their intention is to secure their contractual benefit or contractual rights, or to fulfill their contractual obligations. It's in contrast, the court who is there to help implement the governmental climate policies. So the question arises, but as the judgments could really help in promoting better performance of the low carbon economy, and therefore have a positive implication for climate mitigation and or adaptation. So we still count it as the Chinese version of a climate change litigation, because there are really very few practice that we can identify. But the question arises whether the real climate change litigation could emerge in China, and if it would, through which channel could it be there? Then in order to answer this question, we should first have a better understanding of what is the Chinese government-led regulatory pathway of climate change litigation. There are two major differences between China's regulatory context and that of the most democratic common law countries. The first is the limited judicial activism, and the second, we have a relatively stronger governmental performance in tackling climate change. Limited judicial activism means that the power arrangement, due to the power arrangement of China, Chinese government, Chinese judicial branch is the weakest compared to the government and the legislation. So it would be nearly impossible to count on the court to adjudicate against the government when the law has not prescribed the governmental obligation in enforcing the climate policies. So, while the Chinese government is the absolute center in addressing climate change, and in fact, the Chinese government is really motivated in doing that, because as US is retreating from this field, Chinese government would like to step in, and it has the government, the big Chinese government has really already done a lot of job in this area. And so we can see that instead of the court-driven regulatory policy-making process, China followed a government-led pathway in response to the climate change, leaving court with a secondary supporting role. Having understood that, it would give us a clue about what would be the possible prospects for the Chinese climate change litigation. I think this government-led regulatory pathway could be a double-edged sword. On one hand, for the climate change litigation involving public authority defendants, it would not be a good news, as I just stated, because the court is very weak in front of the government. So it would not push the new rules or new new ideas to fight against the inability of the government. But it's on the other hand, it would be might be a good news for the tort-based climate change litigation. The subordinate because such power arrangements suggest that although the judiciary is weak, but it follows what the government command. In common law countries where the checks and the balance is a doctrine is prescribed by constitutional laws, courts may refrain from adjudicating tort-based climate change litigation while facing political question doctrine and displaced test. But such a judicial dilemma would not concern Chinese judges. Actually, our empirical study shows that Chinese environmental policies with regard to the protection of nature would, by contrast, directly condition the court's behavior, of course, often in an unspectacular yet conscious way. So having understood that, we would like to introduce the tort-based public interest litigation related to air pollution as a potential pathway for the climate change litigation in China. And the reason why we bring up this tort-based air pollution public interest litigation is that they share a lot of the similar legal hurdles with the climate change litigation, no matter with regard to the standing and judiciability, or especially the causation, the injury, and the remedy. They are all facing similar problems when standing in front of the court. For example, it's impossible to attribute any particular damage caused by the climate or pollution-related harm to any particular source of emission. That's a big barrier put there in front of all the claimants, the potential plaintiffs, in order to succeed in the case. So, but all these legal hurdles are no longer a problem, because when there's a will, there's a way. Here, we're talking about, of course, we are talking about the will of the government. The government want to do something, and then the courts will help, will secure the purpose is achieved. So in 2017, there's the central government of China has launched a blue sky protection campaign. And after that, there have been a lot of public interest litigation on air pollution emerged. In this public interest litigations, with regard to the standing, we can see there's no problem, because there are three potential plaintiffs now. One is environmental NGOs, another one, and now the most important one, also the public prosecutors, ever since 2017. And since 2017, the local governments joined the litigation by bringing up the ecological damage compensation litigation. And then of course, there are also, it's very controversial. Someone would say that here, when the local government bring up litigation, it's not representing the public interest, it's representing the state's interest. There's a difference between the two, but we're not going to discuss about it here. And the second, for the causation part, we discovered that among 15 cases, once it concerns the non-compliance with the environmental regulations of the government, the court would easily recognize the establishment of a causal relationship between the emission and its adverse effect to the environment and to the public health. There are still other favorable rules, such as burden shifting rules and relatedness instead of causal relationship, etc., etc. And with regard to injury and remedies, the direct impact of pollutant to the ambient air per se is also recognized as judiciable for remedy. So there are a lot of good news, but will China finally open the judicial channel for climate justice and allow Chinese civil society to push for greater improvements? I think it's all related to this government-led regulatory approach. This air pollutant public interest litigation could serve for now as both substitute and a gateway for real climate change litigation. Now I'm going to share some emerging trends. The first, I think you guys have already know, is that just last month, the President Xi have announced a really very ambitious project to strive to reach carbon neutrality before 2016. I think it's a very good demonstration of the determination of the Chinese government to really do a difference, to really make a difference. Now it's very considering that China is now following this government-led pathway, so the government is determined. So it's very promising that we would have a real climate change litigation maybe in future, very much near future. And so for the trend one is that the consolidation of air pollution and climate change competencies within the newly established MEE. I've already talked about the newly established MEE last time, but there's evidence that MEE this year and last year is really doing a great effort to coordinate the emission of the air pollutant and the climate pollutant. It's a good news. There are a lot of conference, a lot of fundings, a lot of experts now hardly working in this area. I think it's very promising that no matter whether the CO2 would be defined eventually as air pollutant, at least the emission of the CO2, carbon dioxide, and the other air pollutant will be coordinated. It means the ministry is trying to transform the effort of the air pollutant control to the climate pollutant control. So that's what I've noticed as a very good trend, a very good news for the climate change litigation. And the trend two is the active participation of the local governments actually in ecological damage.
Sorry to interrupt. It would be great if you could wrap up in the next minute. Thank you so much.
Okay.
Sorry to interrupt.
Okay, thank you. So, and then I will go to the third trend. I've discovered the first real climate change litigation in China that's because that's okay. Sorry, my time is up, but I would like to introduce this case to you. I would encourage you to read more about this case. It's very interesting case, the Friends of Nature versus the Gansu Power Grid Corporation. And this case is now still pending. It's about renewable energy case. Sorry, my time is up. And this is the reason for which the case is now still pending. I think okay. I would like to introduce a paper written by my friend Zhou Chen. He written about this case, addressing dilemma over climate change litigation. So if you want to know more about this case, you can go to read her paper published last year. Okay, thank you very much.
Thank you, yeah. And I'm so sorry to interrupt you. That's just so much you could say, and I
yeah.
But,
okay.
Thank you so much for sharing with us the groundbreaking research you've done on Chinese climate change litigation. And I use the word groundbreaking because Yue was introduced to climate change litigation via this workshop in 2018.
Yeah.
But she has been prolific, and I'm very pleased to also share that she's just obtained a 4-year grant to look into the Chinese judicial response to climate change. So congratulations.
Thank you very much. Thank you very much. Yeah.
Next, I'd like to invite the next speaker, Sejong Yoon. And we're really, really happy to have you with us today, Sejong, because one of the gaps in our collection was that we did not have a contribution looking at South Korea. And so much has happened since then. So really glad, and I'm looking forward to hearing about the case that you've been working on. Thank you.
Thank you so much. It's a great pleasure and honor to have an opportunity to speak at this conference. So my name is Sejong Yoon, and I'm with Solutions for Our Climate. It's a nonprofit organization based in Seoul. And we just happen to have 4 lawyers in our organization. And that's why one of the reasons we're representing this youth climate litigation in Korea at the Constitutional Court. So Youth for Climate Action is an extraordinary youth action group. It has dozens of members around the nation, from middle schools and high schools. It's many youth activists. And they have been playing a particularly important role in the climate action scene in Korea because of the power of their message as the future generation and also their extraordinary campaign strategies. And from the beginning, in 2018, one of their key objectives of their campaign was to file a lawsuit against the government and criticize them for their inaction. And that's because Korea is pointed out to be one of the most prominent laggards of climate mitigation compared to its responsibility, their current emissions, per capita emissions, historical emissions, all. And their capacity, technological, economical, and political capacity, all of that considered, Korea is not doing its fair share when it comes to climate mitigation. And Climate Action Tracker has marked South Korea highly insufficient. And the current NDC for South Korea is 24.4 reduction from 2007 level by 2030. And that's not that much, considering that Korea's emissions have constantly increased in the past, ever since greenhouse gas emissions have been measured. So we started preparing for this case last summer, around August 2019. And we started looking into different options of how we can model or how we can structure this case. And we went through administrative suit, civil claims, and we landed on constitutional claim because Korea has constitutional court that separately overtakes the constitutional review of the legislative, executive, and also judiciary functions of these 3 branches. And the constitutional claim made the best sense in terms of, because they have the widest standing. And also the message of the litigation was to address the future generations' concerns instead of seeking for monetary damages or other reliefs. And also the scope of judicial review for the Constitutional Court seemed to fit best in terms of separation of powers and the political questions that usually arise with this type of litigation. So the request sought in this constitutional complaint is basically asking for a declaration of unconstitutionality to Korea's climate mitigation efforts. And in detail, it has three prongs. The claim number one is declaring that the greenhouse gas reduction target is unconstitutional because it's insufficient and it's inconsistent with Paris Agreement. And that's the presidential decree of the Green Growth Act, which defines all the climate-related measures. Claim two is, as a factual state, the government has failed to meet its 2020 target, which was set in 2009. And when they were approaching 2020 and knowing that they could not meet it, they revised the target in 2016 to the current 2030 target. So it was not really an enhancement of ambitions, but just a postponement of existing target. And claim three is the attack on the Green Growth Act itself, because it gave a blank delegation of power to set greenhouse gas target to the government, instead of setting a set of parameters by the legislative body to set standards or limitations. And the parties are, of course, the 19 among dozens of activists, 19 Youth for Climate Action activists chose to become the plaintiffs because they had to have permission from their parents as minors, so that had some limitations. And the respondents are the National Assembly for the Green Growth Act itself, and it's the president for the climate target because it disputes the unconstitutionality of the decree. And the constitutional rights claimed in this lawsuit is right to life, happiness, human dignity, right to equality because of the generational inequality embedded in the postponed mitigation actions, state's obligation to protect people from disasters, and environmental right. It's notable that the Korean Constitution since 1980 has a specific provision on the environmental right of the people. And the Constitutional Court has acknowledged an underlying duty of the state to protect its people for its constitutional rights. And that is one of the key legal arguments that we are using in this case. Procedural timeline so far is we have filed this the initial complaint on March 13th. And then we passed the initial review of justiciability and standing, but it does not mean they have finally accepted it. It was just a passing of the initial test. So all the standing and the procedural requirements will be decided at the end of the proceedings. And we filed the supplementary brief in May, spelling out all the climate science and all the details of the impacts. And the government and the National Assembly has not responded. They have not submitted a response yet, and we are waiting for them to do that. Our initial plan was to have their response by now, so we can escalate this dispute, so we can impact the government's decision on the NDC and the LEDS. But that's not really happening yet. So we are asking the court to urge the other party to submit their response in a timely manner. So the key question is whether the state has provided sufficient protection of the constitutional rights for its people. And for this specific standard, the Constitutional Court usually takes a minimum protection test and sees whether the state has implemented appropriate and effective measure to provide at least minimum necessary protection for such right. So it's a little bit looser type of legal test when it comes to duty of protection. And this is quite similar to what the German constitution has. And in Germany, there's a very similar constitutional complaint which was filed quite recently. And because we have very similar legal arguments, we are actually looking into each other's submissions to get help and guidance. So with this test, the key questions will be two-pronged. Number one, will the impacts of climate change infringe upon applicants' constitutional rights? And question two, has the state implemented at least minimum necessary protection? With the first question, we think it's relatively easier because it's a factual question, and it has become very difficult to dispute the fact that the current trends of climate change has become a dangerous level. And to minimize any dispute over the facts, we chose to only rely on information produced or promulgated by the government, including the IPCC reports, all the climate mitigation plans, climate adaptation plans, and climate predictions provided by the Korean Meteorological Agency. And we tried to, and from these set of data, we tried to pick the most obvious and most examples that stand out to the tribunal. For example, this is the map of Busan, the second largest city by the southern coast of Korea. And by the end of the century, the blue highlighted area will be basically underwater at least once a year, making it inhabitable. And that will affect at least hundreds of thousands of people. And this is a map that is provided by the Ministry of Transportation. And it's a government information that they will find it very difficult or unnecessary to dispute. Climate predictions, the Korean Meteorological Administration published a climate change prediction report last year, which states by the end of the century, there will be no ice in Korea. And if you have been to Korea, the winters in Korea are very cold. And then we have lots of snow, we go skiing, we go skating. But our next generation is likely to not be able to experience any of that. It's one of the, we thought that was more like a tangible, palpable examples that could actually get to the tribunal. Fortunately, we have helpful precedents from the European courts, the Urgenda case, of course, and also recent victory from the Irish court. They have accepted the facts of climate change as an undisputed fact. And these kind of precedents outside the country really builds on to our case because the government will find it even more difficult to put on disputes on the facts of the case. And of course, the IPCC sets the scientific basis of the prediction part. So the more important and more difficult question is whether the state is providing enough protection and whether they have done enough. This graph shows the emission reductions targets set by the government and the actual emissions pathway so far. So in 2009, there was a 2020 target of 543 million, but in 2016, noting that they will not be able to reach this target, the government revises the target to 2030 at 536. And so far, the Korean government has failed to peak its emissions. It is still increasing. So it is quite clear from this graph that the Korean government has failed to reduce its emissions so far, and it's very likely that this type of approach will not be aligned with the Paris Agreement targets. So that being said, legally speaking, it is not all very clear whether that graph or not being able to peak emissions is enough to establish that the Korean government has failed. So, and also Paris Agreement does not specify how much reduction should be done by each party. So what the approach we took was we come up with a global approach because it's quite clear that the global emission reduction targets, all the NDCs combined, is still insufficient. And the UNEP GAP report clearly states that we are going to a 3.2 degree increase if we continue with our commitments right now. So globally, we are overshooting. Then how about Korea? Then we compare Korea's NDC levels and historical emissions to its peers that with similar GDP, similar economic levels, and similar political environments. And we picked the OECD countries and compare them at a same plane. And it clearly shows that Korea is far behind, lagging far behind its peers when it comes to its commitment. And also with the historical emissions, most of the OECD countries have begun reducing its greenhouse gas emissions while Korea is still increasing. And that's, of course, we come back to the Climate Action Tracker's assessment of Korea's target, which is highly insufficient. And we intentionally avoid the question of how much should be the target should be for Korea, and what's the right answer for its fair share, because that's a very technical question, and it does not have to be put to the Constitutional Court. The Constitutional Court all the court needs to say is whether the current target is sufficient or not, and it doesn't have to go into then what the target should be. And the government is likely to argue that, well, we are not the only highly insufficient country in the world. In fact, a lot of countries, if not most, have been labeled as insufficient or highly insufficient by Climate Action Tracker. And to that point, the Urgenda case provides a really good answer because it clearly stated that the country cannot escape its own share of responsibility by pointing fingers to other countries' inactions. So if we succeed in the Constitutional Court, and if the Constitutional Court finds the law and the decree unconstitutional, it'll declare it unconstitutional, and the executive branch and the legislative branch will bear the obligation to rectify this unconstitutionality by changing its targets and or changing its laws to fit their mission, and they will be required to come up with a level that is sufficient to provide protection of the constitutional rights and a law that defines sufficient perimeters that would safeguard the constitutionality. So that's one of the reasons we thought this type of structure of the litigation sets well with the separation of powers and the potential question of political policy questions. So we recently had some positive developments, both in politics and the government. Last month, the National Assembly adopted climate emergency resolution. And this morning, actually, today, the president declared that Korea is going for 2050 net zero target. So it's very encouraging, but does this affect our litigation? Not yet, because these are declarations and we haven't seen these kind of changes getting into an actual policy or legal policy that could actually provide constitutional protection for the people. Thank you.
Thank you, Sejong, for such a fascinating presentation. And I just want to say, speaking personally, it's so inspiring to hear about such ambitious litigation being pursued in such a strategically intelligent fashion. So thank you for that presentation very much. Our final panelist is Arpitha, and then we will move to Q&A after her presentation.
All right, thank you so much. Can you see my screen? Perfect. All right, so the way I approach this question of climate change litigation in India is to sort of take you through what the existing landscape has been and to locate the courts in that. What have been the limitations and what are the possibilities for future interventions? And I think to some extent, the Indian story has been one of, hold on, I'm unable to change slides. Right. So a bit of the Indian story has been one where the courts have been very active. It's created sort of a fertile ground where progressive rights-based jurisprudence has developed in the environmental space. And it's been a very exciting arena where, democratic decisions and, decisions on the conflicts of development and the environment have really played out. But with climate change, I think I'd just like to read out a few statistics to kind of locate the debate a bit more closely to what's going on at the moment. So firstly, India is the third largest emitter of carbon. And with the kind of ambitious fossil fuel program that it has recently unveiled with the privatization of coal, it might even supersede China and the United States. Further, 29% of its population is living, in poverty, and it lacks access to electricity. So it's a very visible challenge in the Indian context of how do we balance these competing priorities of economic growth, energy security, and climate change. And the other statistic is India in its INDC has sort of committed to sort of reducing its intensity to the GDP, as in the emission intensity, by 33 to 35%. So you have sort of this contradictory dialectic playing out, where you have an ambitious program to reduce emissions, but you have a sort of a challenge with the political economy question of development. And this is something that we've seen play out in a lot of the debates around environmental law. So climate change becomes, in some sense, a more urgent setting where these existing debates are sort of revisited. Now, just to kind of locate the courts in this discussion. So as I previously alluded, that the courts have provided a really progressive rights-based jurisprudence. The other interesting thing about the environmental governance story in the Indian context is that courts have often acted as a catalyst whenever the government has shown some kind of inaction in terms of enforcing existing environmental laws. And this has been through the route of public interest litigations post the 1970s, which was a legal innovation where local standi was kind of opened up, and you had a lot of civil society actors placing a lot of environmental cases before the courts. And interestingly, the courts have also acted as an avenue for the entrance of international environmental law and these higher legal standards, whether we look at the public trust doctrine or the precautionary principle, and apart from the legislature itself. And the court has also been a site where a lot of the competing priorities that I had earlier mentioned have either been reconciled in favor of development, or sometimes a more nuanced approach to how do we deal with the question of conservation. The other interesting thing that the court has also sort of resulted in is what Cesar Rodriguez Garavito calls the participatory effect, wherein after the case has gone to court, it's actually resulted in stakeholders becoming part and parcel of the decision making. So in the Indian case, you had the Niyamgiri judgment in 2013, where an Adivasi community or an indigenous community was fighting a bauxite mine in the Niyamgiri range in Orissa. And that was the first time that the principle of free, prior, and informed consent entered into Indian jurisprudence more strongly. And what it then resulted in was where the decision of whether the mine was to be established or not was actually taken by the community, and there was an actual environmental referendum. So you've seen a lot of these interesting contributions that the court has made. But at the same time, while one valorizes judicial activism in the Indian context, public interest litigation has also come with its own perils and dangers. And an excellent study by Anuj Buvania in Quoting the People, what he essentially argues is that the communities who were most marginalized, who brought these cases before the Supreme Court in particular, eventually were marginalized by the judgments themselves. So they didn't come off with better outcomes in terms of what they had gone to the courts for. Instead, they came out with a lot more legal costs as well as justice not being delivered. So how does one reconcile that? So you have the courts kind of really pushing for progressive jurisprudence. It's a great site of struggle to bring about climate litigation. But at the same time, there is the danger of the communities who are already marginalized being further marginalized. So I just want you to hold on to that thought. And what I now want to do is sort of zero in on just two cases to demonstrate where things are at the moment in terms of climate change litigation and how some of the existing litigation on forest rights and in the forest geography kind of tells a different story of perhaps the future trajectory that climate litigation in the Indian context should take. So the Ridhima Pandey case is one of the first cases in the sense of where it explicitly spoke about climate change. And it was brought by a 9-year-old from the state of Uttarakhand in northern India. And it came with the expression of violation of rights of children and the younger generation. And it kind of harnessed a lot of the international legal principles. And what I'm going to do is just sort of read out from the petition itself, just a quick paragraph of what it does. So the applicant here is invoking the principle of sustainable development, the precautionary principle, as well as intergenerational equity. What the applicant here raises is the non-implementation of various environmental laws, which in turn violates these principles. And it then kind of looks at India's existing legal framework. And what I think is really fascinating about this petition is that it kind of looks at India's existing climate change law and policy frameworks, existing environmental laws, as well as, international legal principles, but calls upon climate change as a new framing to talk about how state inaction is so visible. And there's sort of a sense of urgency in which that this state inaction has to be rectified. And it also, like I said earlier, kind of harnesses international law to make a broader claim. But the eventual order, sadly, it says that, which came out just in 2019, it says that, there's no reason for the applicant to presume that the Paris Agreement and other international protocols are not reflected in India's government policies. And it further goes on to say that it's something that the government anyway takes quite seriously. And I think this kind of speaks to some of the aspects that Jacqueline brought up as well, where you look at existing environmental clearance processes and looking to extend that to include climate change considerations. And although sufficient evidence was provided in this petition that it wasn't taken on board, this is the eventual order that we have arrived at. But there's an appeal before the Supreme Court, so there's no reason to lose hope. But at the same time, what this particular case demonstrates is it's an experiment in climate change litigation. It looks at how these arguments have been made. And the National Green Tribunal, which is a specialized environmental court, has not really sort of taken on a radical stance or an activist stance on this particular case. The other case that I would like to spend a bit of time discussing is Wildlife First and Others, which was a public interest case before the Indian Supreme Court, which challenged the constitutionality of the Forest Rights Act. To give you a bit more context, so the Forest Rights Act is an act where it recognizes the rights of forest dwelling communities, because prior to that, the colonial legal framework operated on the paradigm of exclusionary conservation. So essentially the rights of communities living in forest areas were not allowed to be exercised or were just not recognized. And so the Forest Rights Act sought to correct that historical injustice. And Wildlife First is an organization that has really rapidly gone after this piece of legislation on the grounds that it's going to fragment forest land, it's going to lead to more deforestation, etc. So underneath a lot of environmental cases in India, whether it's climate change related or not, a simmering conflict is one of community-based conservation and exclusionary conservation. And so you had an order that came out in February 2018, which said that, the forest dwelling communities should be evicted if their rights have not been recognized already. And luckily, there was a lot of social movements which kind of opposed this move, and eventually the order was sort of taken back. But it's still an ongoing case before the Supreme Court. And the reason I chose this particular case, because it again illustrates Anuj Bhavania's telling narrative of PILs, which is that it can push for a more elitist discourse on these questions. And Amita Bhaviskar, who's a sociologist, kind of frames this critique as bourgeois environmentalism, which gets heard in the court space. And so then how do we then look at, using courts effectively, but also being careful about who's the petitioner and what is the argument and how would it play out in the adversarial setting of a court. So I just want to quickly conclude because, and I think Lavanya Rajmani's work on rights-based climate litigation is quite a useful place to look at what the history has been so far. And in it, she kind of talks about a very hopeful note of how we can really harness this rights-based jurisprudence. And I think that's very true. And I think there is a lot of hope and a lot of room for experimentation. But I think some of the challenges, the questions that need to be taken on quite actively and robustly is how do we ground these legal interventions in a way that it doesn't reinforce exclusionary conservation, because there are hard-won battles that have changed the way environmental justice is understood. So in some sense, connecting existing environmental jurisprudence and justice discourse to the broader claim of climate change. The second is who should be the petitioner? How do we be more inclusive? I feel one of the things that very often gets left out in the narrative of younger generation, the younger generation basically filing these claims, is to not look at them again as sort of being homogenous. There are different ways in which different members of the youth community are either marginalized or have certain kinds of privilege to be able to go to the courts. And the point that I had made earlier on the political economy of extraction is India, like I said, the coal mining was nationalized historically, and it was in 2015 that it decided to privatize it, and it decided to even increase its dependence on coal. And there's an interesting case now that's been filed by one of the states where it's challenging this privatization of coal, but there's no mention of climate change as one of the bases on which they're challenging it. Instead, it looks at revenue sharing between the center and the state on the basis of the public trust doctrine, but not really beyond that. And that's something I think that we should investigate in terms of that particular aspect of how far will the claims go to challenge the political economy, and how far will the courts go to sort of challenge some of those economic paradigms. And lastly, and this is something that I feel India has struggled with a lot, perhaps other jurisdictions as well, is that we have progressive judgments, but eventually the enforcement of these progressive judgments has been very weak. So even if we do get a pronouncement which is really exemplar in terms of climate change and India's commitments, how do we then see that it influences governance as well as the administrative and regulatory bodies that pretty much govern a lot of environmental decision making? So I'm just going to stop there. Thank you so much.
Thank you so much, Apita. That was really fascinating and also encouraging to hear about what's been happening in India. Well, we all know that India is one of the foremost places for public interest litigation. So it's a place where a lot of interest is focused on. So I'm going to now start with the Q&A session. And here we have actually got two questions in the chat. So the first question actually, Apitha, that you have is a question from Xiong Xuefei. The question is, could you tell us if the Indian courts have the right to initiate climate change litigation?
Yeah, the Indian courts do have that. They can suo moto sort of take on a case. But the current political climate, I feel, poses a bit of a challenge for the judiciary to be so activist.
Thank you. And there's a follow-up question for you from someone you spoke to, whose work you've referred to in your presentation. So Professor Rajamani, who is in the audience. Hi, Lavanya. Thanks for joining us. Apitha, can you read the question in the Q&A? And I'm going to articulate it for the purposes of the recording. So this question is for Apitha. Thanks for a terrific presentation. To what extent are the prospects for and outcomes in particular cases based on the claims in the climate cases themselves? And to what extent can these be traced to larger developments within which environmental law is set, including the regulatory rollback on environmental impact assessment in particular, reduced support for the National Green Tribunal, etc.?
Thank you, Lavanya. It's nice to see that you're in the audience. So I just want to kind of revisit this question because I feel like it's split into two parts, I guess. In one sense, the question that you're asking is if the cases in which these climate claims have been made, right? Okay. It's kind of difficult to separate them. I feel like we've had a lot of environmental law cases which kind of deal with broader climate change aspects, but are not more explicit. And then you have some cases where it explicitly kind of tacks on to the climate change claim. So the hope perhaps is that a lot of the existing environmental laws and jurisprudence take on sort of a new color and urgency with the sort of tacking on of climate change. But there hasn't been too much of conversation in a lot of the cases and judgments that I have read where that kind of amalgamation of the existing environmental jurisprudence and laws have been extended quite nicely and clearly in an arc to climate change. I don't know if that really answers your question, but there's an attempt to sort of address that. But you're right in terms of the current changes that the environmental regulatory space in India is experiencing. There's an overhaul of the environment impact assessment. There's also been, by the National Green Tribunal, which is the environmental court in the Indian context, has not been funded adequately. So there's been a lot of hollowing out of the robust institutions that did sort of safeguard environmental considerations. And I feel it's an opportune time to be bringing a case before the Supreme Court to really challenge this. But at the same time, with closing of spaces for dissent, etc., it has been quite a challenge. There was an experiment that actually I was trying to coordinate about a year ago, where we tried to bring a climate change lawsuit in India, but out of sheer worry about the kind of arrests that were happening, many of those who initially committed to being the petitioners sort of backed out. So in that sense, I think there's a need to be more crafty and more clever in how we use the judiciary and in the way in which we can harness it. Thank you.
Thank you. The next question is for Sijong. The question is from Minzy T. How novel is your claim? And in the sense that has a similar case been brought in the Korean courts before your case? Thank you.
Yeah, that's a good question, and this was the first case in the Constitutional Court that directly addresses the climate target, and there hasn't really been a climate litigation per se, either with civil or administrative. So this is officially the first climate litigation in that sense.
Thank you. Thank you very much. There is another question. Sorry, this question is for Zhao Yue. Zhao Yue, there's a question for you about, the question is, do you think in the next year, the courts will play a greater role to protect the environment? And yeah, if you would like to take that question, Zhao Yue.
Yeah. Actually, the Chinese courts now is really the central part, the central part where all the branches will go, or all the participators would go to push for our change. For example, as I have stated, at first it was only the environmental non-governmental organizations, and then the public prosecutors now after 2017. But last year, it was the local governments who participated in the ecological damage compensation litigation. And now, according to what I know, there's even a quota for the local governments to bring the suits. Every local government should bring 2 suits per year in order to achieve their the goals. So I am predicting, we can expect a greater role of the judicial branch, the judiciaries, the Chinese judges to play in this process. I think that's definite. Thank you.
Thank you very much. So thank you, Tommy. Yeah, and so we have perhaps room for time for just one last question, and I wanted to give this opportunity to Jackie to speak to the earlier question that she received about the Tory Islanders case. Jackie, perhaps you would like to share some of your views in response to that question.
I'll share some views, Jolene, but I'm going to put it in a broader context, which is to say that we've heard from several of the other speakers and also in the Q&A about the promising prospects for rights-based litigation in the climate sphere. But the question that was being raised in the Q&A is this a prospect in a jurisdiction like Australia? And the short answer that Hari and I have written on in an article called A Rights Turn in Climate Litigation is that prospect might be good in many other parts of the world, but in our home jurisdictions of Australia and also we would say the United States, rights-based litigation doesn't have as many prospects. And in the Australian context, that's because we don't have constitutional rights of the kind, for example, that we heard about in the Korean context. So what we're seeing in Australia is applicants who want to pursue rights-based claims, taking those to international bodies, such as the Torres Strait Islander case that's being pursued at the moment, which is a complaint to the International Human Rights Committee, or some innovative cases that are trying to use provincial level state-based legislative human rights acts to pursue these kinds of claims. But as I indicated in my presentation, a lot of the new generation cases in Australia, while they pursue novel legal avenues, including human rights, this is not such a promising avenue in Australia, and so we've seen more of a focus on some of the corporate law avenues. But that said, there are trends in Australia that match some of the others that we're seeing across the Asia Pacific, in particular, an increasing use of litigation avenues by youth groups to pursue climate claims. So this emerging intergenerational narrative in climate litigation is a really interesting one that I think we're seeing across different jurisdictions as well. Thanks.
Thank you, Jackie. Thank you so much, everyone, for joining us today. It's getting very late in Australia for Jackie, and it's 5:30 a.m. for Doug. Thank you so much for everyone for making the time to be here with us today, and I hope you found it an interesting session. The recording of this webinar will be made available on YouTube in a couple of weeks, hopefully not a couple of weeks, perhaps next week. And hopefully that will be an opportunity for us to share this with a wider audience. Thank you, everyone, and hope to see you soon.